Hi, this is Rahul Reddy. We're live here from Houston, Texas. We're from REDDY NEUMANN PC. Every Tuesday at 5 o'clock, we're live answering question and answers. Along with me is Emily Neumann, my business partner. Emily?
Hi, thanks for joining us today. My name is Emily Neumann. I'm a partner with REDDY NEUMANN PC and also the writer behind the blog immigrationgirl.com, where you'll get practical tips from the desk of an immigration attorney. Today, some of the topics that we're going to be talking about include CPT and the denials that are happening for the change of status from F1 status to H1B, as well as the recent NTA memo and how exactly that's being implemented. We're going to be talking about cap gap, with now that we don't have premium processing for the H1B, those that were in the cap gap, what happens after October 1st. H4 EAD updates, and then we'll be answering your questions live. So thanks for joining us today. Let's go ahead and get started.
If you have any questions, post them in the live, and we will be able to answer most of the questions. Emily, the USCIS has released the statistics with regards to the amount of approvals and denials in the first and second quarter of 2018. They're saying that the I-129 adjudications in the second quarter of 2018, there is a 44% denials in the I-129, which is a form that is used for most of the business immigration. 44% denial, do you believe that? This statistics come directly from the USCIS website. I'm not inventing it. This is the one that we're going to post the same website where we're pulling the statistics to you guys, and 44% denial?
That doesn't surprise me. I mean, we're talking about the second quarter of fiscal year 2018, which would have been beginning in January of 2018.
January of 2018.
So I think that, yeah, we saw a lot of changes in the adjudication as far as specialty occupation denials. We still had issues with level 1 wage at that time. So it doesn't surprise me that there was a big jump.
44% denials? Out of every 100 applications, 44% denial applications on the business immigration? That's not good. That's going to have a lot of these businesses suffering, families getting suffers, people going to school. What is the solution for the people who are filing? What are the precautions that they need to take when they are filing the business immigration applications with the 42% denials?
Yeah, it's all about preparation well in advance of the filing. Know exactly what the requirements are. Make sure you're over documenting. Make sure you have the education evaluation or an education plus experience evaluation if necessary. Make sure that you have a detailed job description that you're submitting. Also make sure that you're selecting a good SOC code. That's the occupation category that the job falls under. You put that on the LCA at the very beginning of the process, and that sometimes determines the outcome of the case. And also just reviewing the letters of support that are being submitted. We've found some cases where some of the language used in the letter of support in the initial filing is what caused the denial later on when it comes to what the education requirements were mentioned in the petition. So just because you've used the same letter over and over again for 20 years, you still need to review that, revise it, make sure it's updated based on what the current requirements are and based on the current adjudication trends.
I've noticed that one of the common errors that when I get the consultations, Emily, I get the copy of the H-1B petition or the end client letter or probably the employer letter. I see the language for the software professionals when they file the H-1B. They're using the language that the position requires bachelor's degree in computer science, engineering or related, and the USCIS is denying the application because the word engineering is used, because once the engineering is used, what they're telling is that there are about 32 different degrees in engineering. So it's so broad enough, the H-1B, they're denying based on that. So the language that probably would have been okay in the previous 10 administrations is not okay right now in this administration. So system analyst position, which was a sacred cow for a lot of time, now is not anymore. It's probably one of the highest reason for denial. In the 44%, that is good percentage, was because of this system analyst position that got denied. So if you want, you may want to have your application reviewed by a second lawyer, have a copy of the H-1B petition to be reviewed by a second lawyer, an experienced lawyer, the one who does it very regularly. You may want to get it done, because that's very crucial, because it's going to determine whether you're going to stay in this country or not. It's going to determine the employer cannot employ this person based on that. Now, since the premium processing is not there, you don't want all these things to be revised once you file an application, because you're stuck with the application. You can't change what has been submitted. So you may want to, as Emily pointed out, be careful when you're submitting the application to review it carefully to see what the current trends are, not what the H-1B is. What it was is different. It is what the current trends are in the business immigration application. Because what was been done for past 20 years is no longer valid now. So if the current trends, you forget it, you might be having a denial. And that's the reason 40% denials are there.
Yeah, it's really important to point out, just to remind everyone, that just because you were approved last time, or maybe the last 2 times or 3 times, does not mean this time around you're going to be approved. You know, we've had situations where after the person's been in H-1B status for 8 years, now all of a sudden we're seeing a request for evidence asking us how the beneficiary qualifies for the job, the same job that they've been in, because of a difference in the educational qualifications, and now we have to go back and use education plus experience to qualify. So again, just because it was approved before, there is no more deference to prior adjudications based on USCIS policy. So you really do need to look at everything with fresh eyes again, and also file early. Without having premium processing for a good portion of the H-1B petitions, it can be a major problem when you file too close to your I-94 expiration, and then after your I-94 expires, you end up with a denial. There's not much that can be done from within the U.S. to overcome that. So filing early can buy you enough time to try to refile or file a change of status to something else if things go poorly.
Emily, with the CPT, particularly, all these people are going to a university. I don't want to name it, but I can name it. Should I name the first word of that, or should not? Not first alphabet of it. No, I don't want to name it. But they're all going to the same university. They're getting the CPT. You have won many times. And now every day in the daily conference call that I have, every day that I do conduct, and I'm getting a lot of consultations for the change of status denials for those people who have got the day 1 CPT and have applied for the H-1B. Now, in light of the August 9th memo, it's quite different last year than this year. It's going to be quite different next year compared to this year. Can you educate the audiences with regards to what is the difference? Why is the CPT a problem, day 1 CPT a problem? And what's the difference between the last year to this year? And what will be the difference in the next year?
Sure, there's 2 issues that come up with CPT. Number 1, USCIS is now taking the stance that if you've used all of your OPT time and you're going back to school at the same degree level, that you're not eligible for any kind of practical training. In the past, we all understood that to be interpreted as you couldn't do more OPT at the same degree level. Now they're saying you can't do CPT at the same degree level if you've already used up all of your OPT time previously. So that's issue number 1. And then issue number 2 is the CPT properly authorized when it's being given before you meet the 1-year requirement. So the base requirement for CPT is that you've been in school for 1 year before you're eligible. Some of these schools are kind of using an exception to that rule if the program requires immediate participation in practical training. Now, the programs that are giving this tend to be only for international students. You don't see the typical American student in those programs, which makes you wonder, why that is. It's because they're catering specifically to international students.
Do you consider them students, Emily, if they don't even go to classes? All they're getting a work permit, they only conduct one class in a semester or one class in a month?
Yeah, I think it's difficult to say that you're here studying, which is the purpose of the F1 visa, when you're really using that visa as a way to work 40 hours a week and go to class on the side. So those are the problems that we have with these CPT, and what we're seeing in the change of status from F1 to H1, USCIS is now denying the change of status on the grounds that the CPT was not properly authorized. Now, prior to this year, when that happened, you received your I-129 approval notice. You did not get a new I-94. You left the country, you applied for your visa stamp at the consulate, and you came back in H1 status, and it wasn't that huge of an issue. That all changed with the August 9th unlawful presence memo for F1 students. Now, it's not just a status violation that requires you to leave the country. It's a status violation which now causes you to be unlawfully present. Now, unlawful presence in and of itself may not be a huge problem. It's the amount of time that you're unlawfully present. So the rules are, if you are unlawfully present in the U.S. for 180 days, when you exit the country, you trigger a 3-year bar to coming back. Meaning you got this great H-1B approval notice that's valid for 3 years, you exit, and if you've already crossed 180 days of that unlawful presence, you can't come back using that approval notice because you're banned for 3 years. Your H-1B approval is going to expire before you can ever apply for that visa. If you cross 365 days or 1 year of unlawful presence, then you trigger a 10-year bar to coming back legally. So how do we get to these 180 days? With the unlawful presence memo, the really difficult part of it is when they say you violated your status, the unlawful presence doesn't begin from the day they say you violated your status. It began from the day you started violating your status, or August 9th, depending on whichever is later. So for those that are currently in this CPT and have H-1B change of status pending, if your change of status is denied because of a status violation, you began accruing unlawful presence on August 9th. So if you don't exit the country by February 4th, you're going to trigger that bar. Now, so you have some advance notice. You know that February 4th is the date to worry about. But what about the people that are going to be filing in April? So say we have
April of 2019.
Right. So we have some people who their cap gap ended on September 30th, and they're choosing to go back to school and do these day one CPT, and they're asking, what's going to be the impact next year? Well, think about that. You're starting day one CPT, which is potentially a status violation, on October 1st, 2018, and you're going to continue that status violation at the time you're filing your H-1B next April, and maybe you get an adjudication of that next September where they decide that you violated your status. You've now been unlawfully present for 11 months. If that denial comes after October 1st, now you've crossed 1 year, you're banned for 10 years. I hope it was worth it. That's just a huge risk.
A lot of people will come and ask me questions, Emily, what do I do? I'm getting out of cap gap. I'm not allowed to work. As you know, Emily, that if the cap gap ended on September 30th, and after that, if the H-1B is pending, they cannot continue working. What do I do? And I lose my job, I lose my H-1B, what do I do? We do understand those situations. What we're looking is that not the temporary fix which you're going to have, a permanent bar for you. It's definitely not worth, because I'm looking, it's worth for you to leave the country if you cannot just go to the proper college, you can leave the country. But if you take these day one CPTs, you're going to have a long-term effect that you may never be able to come back into United States. These hard times will be gone. I mean, they won't stay forever. You can always go back to India or whichever country you're from and come back again later on. But if you take these CPT, day one CPTs, you're going to have a bad thing in your whole life. You may not be able to come back into this country. So that's what I am looking at, the day one CPTs that I'm worried about. I mean, let's go back to some of the questions that are there. I have my I-140 approved for more than 6 months. Can I apply for multiple H-1B transfers using the same I-140 to different companies?
Yes, the I-140 approval remains valid for you to get H-1B extensions beyond the 6-year limit with the same company that filed the I-140 or with a different company or 2 or 3 companies down the line. So there's no restriction on what company you can use that I-140 approval for. Now, should you apply for multiple H-1B transfers at the same time? I think that really depends on the situation. I've seen some situations where that's a huge risk, where there's really only one job, but you're filing with 2 different employers for the same job. I think that's a problem. But if you have 2 genuine offers of employment that are completely separate, maybe it's possible, but it does create some complexity to the case.
Yeah, the only thing that I'm looking at is if the end client and the employer consulting company files for the same job, that might create a conflict between both the employers where the job belongs to. But if the 2 companies separately, nothing to do with each other, are filing for completely 2 different jobs, I don't see that it's a problem when you're applying for a transfer. I do genuinely feel that if it's a quota case, you're trying to circumvent the quota, that might be a problem. When you're filing a transfer, I am fine. It looks to be fine to me, Emily.
When it's the same end client?
No,
Oh,
if it's a different places. If the same end client, the consulting company and end client is filing, that looks to be a little bit conflicting. But if it's different positions, different titles, different places, I don't see as a problem. Emily, Sham has this question that he has an H-1B extension to be filed and the end client has moved within 5 miles. Everything remains the same, end client falls within the same MSA. Can they file the H-1B extension in premium processing in Nebraska Service Center?
I would say most likely yes. I think that's probably not a material change. So for the most part, that's an extension without change. But just be aware that USCIS could disagree with that. It is a risk. There's no guarantee that they're going to accept that. That being said, it seems that they're accepting most situations that we're filing it as an extension without change right now.
Vikas has this question. He has an I-140 approved. It's going, and the priority date is 2017. He has a brother who is a U.S. citizen. Can the U.S. citizen brother file an I-130 application, green card application for this brother? Will that be a conflict, having an employer filing an I-140 and the brother filing an I-130? Absolutely, it's not a problem. It's not a conflict that you have an employer who wants you. It's not a problem that you have a brother who is a sibling and is filing. Absolutely not a problem. You can have both of them going parallelly. It's not a problem at all.
Nilesh has a question. We've talked about this before, the idea of downgrading from EB2 to EB3 using the same labor certification. He wants to know what happens to the EB2 I-140 if you downgrade to EB3. Is that still valid?
That's a tough question. I don't see why the EB2 is not valid when you're downgrading. If the company has not withdrawn the I-140 application of the EB2, they're just downgrading, they use the same labor certification application to get an EB3. I don't see that the EB2 is invalid. Do you see that, Emily?
No, I agree. I think that both of them are valid and you can use whichever one happens to become current first.
Cap gap people, Emily, what is this cap gap? And cap gap ended on September 30th. Can they work right now?
Yeah, so for those who had OPT that was expiring sometime between April and October and filed a change of status to H-1B in April, while it's pending, you're in the cap gap because the H-1B is not going to take effect until October 1st, and your employment authorization is automatically extended through September 30th, the idea being that your H-1B will be approved and take effect on October 1st. So the gap between your two statuses is covered and there's no break in employment. Sounds great until we deal with USCIS processing times where a good number, probably, I don't know, I've seen some attorneys saying like over 50% of their cases are still pending. We have probably, I think about 18% of ours have been no action taken whatsoever by USCIS on them since April. So those individuals that were on the cap gap and now we've crossed October 1st, your cap gap ended on September 30th. That means you have to stop working. You no longer have employment authorization. From October 1st, you enter your 60-day grace period. That's at the end of your OPT time. And then after that, if your H-1B is still pending, you can remain based on the pending H-1B. You're in a period of authorized stay as long as that H-1B change of status remains pending. The risk there is that if your H-1B ultimately gets denied after your grace period has expired and you've just been relying on the period of authorized stay, your period of authorized stay immediately ends on the date of the denial, and you immediately begin accruing unlawful presence from that day as well. So once that H-1B is denied, there's not a lot of options for you to get back into any other type of status without exiting the country. Whereas if you're still in your grace period, you do have the option of filing a change of status to something else to cover you in between while you're waiting for the H-1B decision, or you may be able to enroll in a new program with the same school or a different school. Just be aware that, again, we do not recommend day one CPT for that, so the best thing is to stop working unless you're changing status to some other type of visa that allows you to work.
Jitendra has this question with regards to the system analyst position. He submitted all the RFE responses. The H-1B was when filed in the system analyst position. What are the probabilities of approving? It's going to be tough. We have to see the H-1B petition. We also want to see the job description, the level of the salary, the documentation that we've been used, the RFE that was being issued, the document that we submitted to the RFE. It's going to be hard to judge. In general, though, system analyst position has a lesser chance of approval. That is a fact right now, but we have to still look into all different factors to say whether or not it's what are the chances for approval.
Shyam has a good question kind of on that same lines as the cap gap OPT, but in this situation, the OPT is still valid until this December. So for an individual who has the H-1B change of status pending, still no answer on it, but your OPT doesn't expire until December, you can continue working based on that OPT. There's no problem with that. You keep working until the card expires, and then once the card expires, if the H-1B is still pending, you can remain. You have your 60-day grace period. After the OPT expires, then the period of authorized stay. If your H-1B gets denied before the OPT expires, your OPT most likely remains valid unless there was some sort of determination of a status violation. So you can continue on that OPT until it expires, even if the H-1B has been denied in that situation.
Anjali has this question that she has filed an H-1B extension. The H-1B extension got denied. Her I-94 has already expired. Can she file another H-1B extension because she has the I-140 approval? I would not advise at this point of time for you to file the extension once the I-94 has expired, because you may be accruing the unlawful presence since the time of your extension denial. Since the I-94 has expired, you do not want to take any risk. I would recommend that you leave the country. You can always file the H-1B in the consular processing, but if you accrue the unlawful presence, you might have a bar on your coming back into this country. In fact, we have published an article today because this 180-day rule and the 3-year bar and 10-year bar is coming up so much, because we have not seen this kind of denials before. In my 23 years of immigration practice, I have not seen these kind of denials, and that's the reason why I'm more concerned about this 3-year and 10-year bar. I have published an article today in rnlawgroup.com. Go to the news section. You might be accruing the unlawful presence, and if you touch the 180 days, you are going to have a 3-year bar, and you are going to have a 10-year bar if you're going to touch the 365. So if you file another extension, you'll be risking too much. I would not recommend. Now, REDDY NEUMANN PC was formed back in olden days in 1997. Law Office of R.V. Reddy was formed on April 1st of 1997. When I formed this organization, I had a significance on why I started this organization April 1st of 1997. April 1st of 1997 was the implementation of the IRA law, which was passed at that point of time. The 3-year bar and 10-year bar started on April 1st of 1997. I choose that day to form this Law Office of R.V. Reddy, which is now called as REDDY NEUMANN PC, on that day of April 1st of 1997. So yes, we are aware of this 3-year bar and 10-year bar. We know all along from 1997 what a 3-year bar, 10-year bar is. But it has become so significant right now with the denials, and not only with the denials, with the August 9th memo, which is kicking in for the student visa people. A lot of people will be affected by the 3-year and 10-year bar. So I'm looking, as being an immigrant by myself, I'm looking into you and saying that if there is a risk that you're going to take the 3-year and 10-year bar, I would not like you to take the risk of 3-year and 10-year bar. And with, as Emily has pointed out, 44% of the I-129s are denied according to the USCIS statistics, not my statistics. That's a very significant amount. I would like people not take the risk. Maybe wait for your time. Maybe if you have to leave to your home country, you leave, but don't accrue the 180-day unlawful presence. Don't accrue the 365. You might be barred for a long period of time to come into this country.
So this IRA law that's been in existence for 21 years,
right?
We've known about the 3-year and 10-year bar for 21 years.
Yes.
How many employment-based cases have you seen where people were subject to the 3 or 10-year bar in your 21 years?
Very rarely, Emily.
Yeah.
Very rarely have I seen the 3-year and 10-year bar getting kicked off. I would say that maybe one a year, maybe one in every other year, I've seen them getting kicked into the 3-year and 10-year bar when they're unlawfully present here. There are multiple reasons. One, the August 9th memo was not there. If the person was being determined to be out of status, the day that they were determined on the F1 status, that's one thing. Most of the time, the premium processing was there. So if there is anything like a problem like Anjali was there, the unlawful presence for Anjali would begin since the day she got the denial. So if there is any other person who has taken a risk, you still had the premium processing, you get the decision within 3 to 4 weeks, and then you still leave, so you still are not, you still are under the 180 days. But now, with no premium processing, the administration is poised to deny your application. It's not worth taking risk. Yes, in 21 years, the amount of people that I have seen in the 180-day and in the 3-year bar and 10-year bar, and the ones that I'm going to see now, and I'm seeing raw, I think so. I have seen more 3-year bar and 10-year bar kicking in the past 6 months to 1 year than I have seen my entire 21 years of immigration.
And how about NTAs? I mean, we see denials from time to time.
Never seen an NTA. 485 denied, there was no. Emily, let me present what an NTA is. Notice to appear. That means that when a person is out of status, or if the USCIS considers that the person is out of status, they will issue a notice to appear in front of the immigration judge. So that notice to appear normally used to be only in very extreme cases where the person has committed some major crimes, not when the change of status getting denied, not when the extension of status is getting denied, but now the NTA memo has been passed and it's now been implemented. Emily, you have published an article on it. Can you educate how the people who are taking the risk might be affected with that NTA?
Yeah, so the NTA memo was published in the summer, and it was supposed to start being implemented by USCIS officers when they issue a denial. Now, it was delayed for 30 days, waiting for USCIS to put in place their process for how they're going to issue these NTAs. After that 30 days, they kind of changed their mind and put it on hold so that we didn't have any issues with NTAs during that time period. However, October 1st of this year, we received the announcement that starting October 1st, USCIS will be implementing that NTA policy specifically for denials of I-485 adjustment of status applications and I-539 change of status applications, or extension of status applications for I-539 specifically. So these are the applications, the adjustment of status, that's your last step of the green card process. If you receive a denial of your 485, and at the time of the denial your I-94 has expired, you are subject to USCIS issuing an NTA to put you into removal proceedings. If your change of status to H4, for example, or a B2 extension has been denied and your underlying I-94 has expired, USCIS can now issue an NTA beginning October 1st.
Don't forget the F1s, a lot of denials of F1s are coming.
Yeah, so if you filed a change of status to F1 and that application ultimately gets denied, which we're seeing quite often just because people don't understand the long processing times.
And they have to maintain the legal status until the F1 is approved.
Right, and there's this requirement of applying for a bridge application if you're not going to maintain your prior status. People are not aware of that, and they're going to end up with a denial of the F1, and that could trigger, it should trigger an NTA under this memo. So now the way they're implementing it, they're saying that they're going to give the appeal time, the 30 days, before they will issue that NTA. So if you are going to exit the country before that 30 days is reached, you shouldn't be subject to the NTA. But the problem is if you're going to stay, an NTA will be issued and you'll end up in deportation court rather than working as a high-skilled immigrant or finishing your studies or whatever it is your purpose was going to be. So that NTA memo is something new, and that combined with the unlawful presence memo and all of that combined with IRA finally being really implemented, it's not time to take a risk with your immigration right now, that's for sure.
I want to go to quick answers, Emily. Mega has this question with regards to she filed a H-1B, RFE is there, it's not approved, and she wants to go to India. No, your extension will be automatically denied. Now, I disagree with your employer, by the employer, since it's an extension, the extension will be denied. You have to file another H-1B, but you will not be subject to cap. You have to stay in India or whichever country you're from, and then they have to apply one more H-1B. You have to wait for the H-1B to be approved and get it stamped before you come in. So it's definitely not worth for you to leave the country under any circumstances, because that's going to put you in big trouble. You're unnecessarily causing the trouble, so I would not leave the country.
Raju has a question, based on the current scenario, and we're talking about this 44% denial rate, is now a safe time to file a transfer, especially that we don't have premium processing? It really depends. There are some risks inherent in filing a transfer. If you are filing with a strong company, strong job description, strong SOC code, good wage level, with an experienced immigration attorney taking care of that petition, we're getting tons of transfer approvals. So yes, you can certainly file a transfer and be successful. But you've got to be really particular about what company you're transferring to, what kind of job you're trying to take, and make sure that it's safe before you make the switch.
Yeah, probably if you have a direct job instead of consulting, you definitely have a brighter chance. If they have a law firm that can represent you, that understand the trends that is going on, you have a better chance of approval, definitely. Now, we know that, under the current circumstances, we are recommending people, joining an end client probably would be a better option because of what's going on in the industry. So it may be good for people if they have good opportunities to move to the end client directly. It might be worth for you.
Srini has a question, just wanting a quick update on H4 EAD. No changes yet. We're still expecting a proposed regulation. It sounds like that will happen towards the end of the year, maybe in December. So we do expect a proposed regulation that would rescind the H4 EAD, but until that's actually final, everything remains the same. You can continue to file.
In continuation of that, Gayatri has this question. She completed her 6 years of H1B. She's on H4 EAD. For her to get back into the H1B, does she have to stay outside for 1 year and apply for the lottery? Gayatri, I have a very good solution for you. You have completed your 6 years. You are on H4 EAD. On H4 EAD, you can file the labor and get the I-140 approval and use that I-140 approval to resurrect your H1B, and you can get the H1B beyond 6 years. Let me tell you one more time. On H4 EAD, you can get the I-140 approval and you can resurrect your H1B and move beyond the 6 years of H1B. If you want to go the other route, if you want to get a H1B, you have to go outside the country. You stay outside the country for at least 1 year. Then you apply in the lottery, which you have 1 in 3 or 1 in 4 chances to get in, and get in. By staying in United States on H4 1 year, you are not completing the task. The easier thing for you is to apply for the I-140.
All right, Ravi has a question kind of about what we were talking before about the H-1B still being pending and your OPT is valid maybe until December. Is it safe to stay and wait for the H-1B approval, or should you leave the country while it's pending? Now, assuming that you're maintaining your F1 status and properly complying with all of the OPT requirements, you can continue working through the time your OPT ends and stop working at that point. Now you enter the 60-day grace period. You can stay in the country during the 60-day grace period. After that point is where the risk comes in, because if your H-1B is denied after that point, after the 60-day grace period ends, the denial puts you immediately out of status and you immediately start accruing unlawful presence. So if the denial happens and from that point you plan on leaving shortly thereafter, there's not a whole lot of risk. But if you're wanting to stay in the event of a denial, you need to take action before your grace period ends to either change to another status or enroll in a new program and continue your F1 stay.
Ravi has a very good question. His OPT is ending on December 14th. Can he stay in this country, or does he have to leave the country? His H-1B is selected in the lottery. It's not adjudicated. No, and his question is, Emily, is that is he accruing the unlawful presence? If he stays beyond December 14th, that's when his OPT is expiring. If your H-1B is pending and you are on OPT, if you stay beyond December 14th, you are not accruing the unlawful presence. Assuming that you maintain the F1 student visa status, you are not used the CPT, day one CPTs, and your OPT is expiring on December 14th. And if the H1 is not adjudicated, you are not accruing the unlawful presence. You will only accrue the unlawful presence after your H1B has been denied. So you are safe to stay in the country after December 14th, but you cannot continue working on this status. You cannot continue working. There are a lot of options that you have. You can stay in this country. If you want to continue working, if the company gives a remote working options, you can go to your home country and you can work there, absolutely not a problem. In that case, you will get the H-1B with the consular processing. You can approach the consulate and apply the H-1B. You will not be accruing any unlawful presence. So either you can stay in this country and not work, or if the company allows you to work, you go to your home country and work. Both of those things are better options for you.
Chita has a question about going for stamping while an amendment is pending. We would not recommend that. It's very likely that you would end up with a 221G, putting everything on hold until the amendment can be processed. Because at that point, you're showing up with a different H-1B petition than what is in the PIMS system. The petition is entered into the PIMS system for the consulates upon approval, and so until the amendment is approved, the consular officer doesn't have access to anything related to that amendment filing. And so if you show up with a different petition with a different work location, it's very likely they're not going to adjudicate that visa application until the amendment gets approved. So I would not recommend going for stamping until after you have the approval.
Mohammed has this question. He has moved from company A to company B. Company A has withdrawn the H-1B. Company B has denied, the company B's H-1B transfer has been denied. Well, if the company A has withdrawn and the company B's transfer has been denied, you are out of status. Whether you are accruing the unlawful presence or not, you may want to check with your lawyer. If your I-94 with company A has expired though, you definitely are accruing the unlawful presence. If the I-94 with company A is still valid, though they have withdrawn that H-1B, you may want to check with your lawyer if you could file one more transfer, one more extension, or you could, whether you're accruing the unlawful presence. I would recommend that you check. But I can tell you one thing clearly. If the I-94 is expired and the company B's H-1B denied, you are accruing the unlawful presence. If the I-94 is valid but withdrawn with company A, you want to check with your lawyer if you are accruing the unlawful presence.
We have a question about premium processing. This one is regarding an I-140, but the same applies to an H-1B. If a pending application has been converted to premium processing, what is the process? What happens after that? So once the premium processing is accepted, USCIS has 15 days, 15 calendar days, not business days, in order to either adjudicate the application or send a request for evidence. So if it's been more than 15 calendar days and nothing has happened, first I would of that premium processing.
One thing, being an L2 EAD, can I apply for the GC? Yes, you can apply for the green card application, absolutely no problem. Even though your husband is an L1A and they are not applying for the green card, you can apply for the green card. I'm not sure what benefit it's going to do. If you are born in India, it might take a long time, 140 years or so, for you to get the green card. But yeah, you can apply for the green card. Absolutely, technically, you're fine to apply for the green card. Maheshwari has this question. I got a 221G for a H-1B when I went to India. Then I applied for the H-4 visa. I got the H-4 stamping and came back to USA. Now I want to apply for a change of status from H-4 to H-1B. Can I work on the receipt notice? The answer to the question is no. You cannot work on the receipt notice. You have to wait for the H-1B approval. Since you're moving from H-4 to H-1B, you might not be subject to the cap because you've been counted previously, but you have to wait for the H-1B approval. My sincere advice to a lot of people who are traveling, who wants to travel, and I come from the immigration background, I mean, with 44% of the I-129s getting denied, now you got all the approval. If you are making a trip to India, I mean, and then this 221G, please try to cut down the trips if you don't have to. And if you're making the trips to India, to your home country, while you're here, and you don't need to go there legally, if you have to go there, I would recommend that you sell everything you have. House, cars, everything. And then you go there, you apply for the visa, you get it, you come back. You don't get it, well, at least you don't have the big hassle of selling and, car, apartment, house. I mean, these are big things to be considered when you're going to India, when you go for stamping. If you can avoid that, I really appreciate if you can. Pretty much covered most of the questions.
I think so, yeah. So if we didn't get to your question or you want more clarification, you can always set up a consultation with either myself or Rahul or any of our attorneys by going to rnlawgroup.com. You also can join our free conference call that we have every day. You can get details on our website, rnlawgroup.com. And if you want to keep up with the latest, you can subscribe to immigrationgirl.com, or you can follow me on Twitter @immigrationgirl and keep up with all of the latest news that's going on. So thanks for joining us today.